Criminologists, they devote themselves to, as we discussed, measuring, understanding, and controlling crime and deviance. But what constitutes crime and what constitutes deviance? I mean, deviant behavior in its general definition, conduct that departs from the social norm, right? And it can include a broad spectrum of things, ranging from a horrific murder to something not so deviant, like getting a face tattoo. You might not think that's deviant, but some folks would think that's deviant. And deviance is dependent on the audience. It's what's the social norms that are around us and our accepted norms and behaviors that define a specific group. Everyone in society has done something that someone else would disagree with, and they would see it as deviant. But not all acts that are criminal are deviant, and not all acts that are deviant are criminal. A deviant act becomes a crime when it's deemed socially harmful or dangerous, just as it says, right? Socially harmful or dangerous. And then it will be specifically defined, prohibited, and then punished under a criminal law. And it'll be specified. It'll be specified what it is, what you cannot do, and if you do it, you will be punished, and this will be the punishment. That's what will occur when a deviant act is a crime. But also, deviant acts that were once criminal can be decriminalized. And again, it changes with social norms. Look at recreational drugs and marijuana. Right now we're seeing decriminalization of marijuana. It's slowly but surely, but it's happening. It also works the other way too. How does a deviant act become criminal? And the book actually uses marijuana, like backwards, and in the same with the same example. But what happens is folks campaign, and they persuade public opinion, and then legislators pass laws. Here's some common ones that have changed over time that were non-criminal. They were deviant behaviors that became criminal crimes. Wearing a seatbelt. When I started driving, I drive a car without being required. It wasn't against the law to drive a car without a seatbelt. Now you can be ticketed for not wearing a seatbelt. DWI. Driving while intoxicated even in the 70s, I think early 80s, we might have seen our first DWI laws. So as you see, things like those, campaigning. Criminologists do studies. How many people die in car accidents when not wearing a seatbelt? How many lives can we save if people wear seatbelts? These kinds of studies are what some criminologists, not all of them, study. And what they're also looking at is what they're concerned with, that fine line in the middle of deviant behavior to the crime to the deviant behavior. And there are three common concepts of crime used amongst them that define what constitutes criminal behavior and what causes people to engage in it. And I guess I should have switched here with my examples before. I just kind of went through these examples. Becoming deviant acts are criminalized when they become crimes, and they can also be decriminalized. We just discussed all that. All right, the views. Nice little chart. I think this chart is even in the book. The consensus view. Let's expand on it a little bit. It's a view which, as it states, it implies agreement, right? Agreement among the citizens on what should and should not be illegal. And this idea implies that everyone comes together, regardless of social class, race, age, and gender, etc., and they determine what should be illegal. And this view also suggests that criminal law is a function of those beliefs and those rules, and that the rules will apply to everyone equally in society. And this is the most common view, common approach. And it also works for decriminalizing the laws as well. where the majority of the folks come together and agreement amongst the citizens and determine what should not be a law. All right. I guess before I move on, I want to give an example. I know I mentioned decriminalization of the law, and you can always refer back to I think this book and a number of the other books that I'm using throughout this semester in other classes. When we talk about decriminalization of law, marijuana seems to be the prime example because we're going through it right now. And countries like Canada, the entire country has made it legal. Our country has not. It's just been decriminalized state by state. There's only a handful of those states. New York is one of them. But on the to give you an example of a majority of the people thinking that a crime should be a crime, murder. I think everyone can agree that killing somebody intentionally should be a crime. That would be an example of the consensus view. Then we have the conflict view or perspective. And this is going to be associated with that Karl Marx theory that we've recently talked about. This view sees society as a collection of diverse groups that can include owners, workers, wealthy, poor, students, professionals, young, old, etc. And this view recognizes that the creation of laws is unequal and may not have a consensus. So it's kind of the opposite point of view. And it suggests that these groups are in constant conflict with one another. It also suggests that crime definitions are controlled by those with wealth, power, and social position in society. And the criminality here shapes the values of the ruling class and is not of moral consensus, quote unquote, moral consensus. And this is really shaped in the laws, as they point out, for an example, the white-collar crimes versus the street crimes. White-collar crimes involve more business, corporate, issues, embezzlement, securities, fraud, breaking environmental laws. And generally, those are punishable by excessive fines, minimal incarceration time, while street crimes, theft and arson and rape and murder have very harsh penalties that are imposed on the street crimes versus what they call, quote unquote, wealthy white collar crimes. Then we have the interactionist view, which states that the definition of crime reflects the preferences and opinions of people who hold social power in a particular legal jurisdiction. Now, what do I mean by that? These individuals, they use their strength of their position. They encourage others to follow their moral stance, and they are called moral entrepreneurs. They create the rules, and they argue their causes will better society. Again, the one, I don't know if this is in the book or not, but an example of this is when the automotive industry took off way back when, 1920s, 1930s, and people were getting run over by cars because everybody was using the streets, right? People were in the streets, they were walking in the streets. This whole concept of cars was new, and the auto industry pushed for laws making it a crime on the people in the street and getting hurt. They call it, that's where the term jaywalking comes in. Jaywalking, when you're not in the street properly, an improperly marked street, is what we think of now because we're used to having cars, and now we got the crosswalks and so forth. But back when cars were new to society, the auto industry really pushed for crimes, to have crimes put on the pedestrians. How about the pharmaceutical industry? Let's talk about those folks under this point of view. They want to keep drugs illegal. They want to keep marijuana illegal. Why? Because it affects their bottom line if it was made legal. So they try and take a moral stance and to keep the rules and argue their causes. It's better for society. It's harmful, to society to allow that street drug to be legal. So those are some examples. How do criminologists define crime? The definition of crime will take from each one of those concepts. I know they're different views, they're different perspectives, but the definition comes from each one of those concepts. So a crime is right, as it says, a violation of societal rules of behavior as interpreted and expressed by the criminal law, which reflects public opinion, traditional values, and the viewpoint of people currently holding social and political power. And individuals who violate these rules are subject to sanctions by state authority, social stigma, and loss of status. So that's how criminologists define crime. So let's talk about criminal law. Criminologists must have an understanding of criminal law in order to be able to analyze criminal behavior. So let's talk about how law has developed. We're going to spend a little time here. So our first type of criminal law was created by the king of Babylon, the Code of Hammurabi. Nope, I knew I'd fumble it up. Hammurabi is how it's pronounced. And it's the gist of this criminal system was eye for an eye. It was more like if you stole from me, you get your hand chopped off. If you kill someone, we kill you. It was an eye for an eye. Think of it that way. And from there, the Mosaic Code was created by the Israelites, and this includes the 10 Commandments. So we're talking about the time, the 1200 BC. And as you may be aware of, the 10 Commandments is the foundation. It was the foundation of the Judeo-Christian teachings. And what you may not know, it's also founded in our modern U.S. laws. Think about it for a minute. How do the 10 Commandments fit into our U.S. laws? Thou shalt not kill, right? We have murder is a crime. Thou shalt not steal. Theft. Thou shalt not commit adultery. While adultery is a crime, it is not prosecuted much. And I bet there's a whole lot of states with the law still on the books, but it's not prosecuted. But nonetheless, it's still, you can kind of still see it amongst the modern U.S. laws. So from there, we have something called the common law. And this was the law that distinguished from our, let's call it the church law. And it was developed in England as a single law system, and it was worked out between jurists, those were kind of lawyers back in their day, and judges. And how it's created is after consideration of many cases involving similar facts. The judges would begin to look to those past cases over time and call them precedent. Stare decisis, let the decision stand. So rather than every time faced with the same set of facts in a case and coming up with a different solution, they'd look back to what they did before. And over time, that has made our cases, the common law cases. Lawyers today can look back at precedent. It's also called authority. I can't walk into court and ask the judge to do something for me without having my precedent or my authority. The judge will ask for it. Do you have any authority for that request? And it keeps continuity. So we know it's going to happen. If someone was to come to my law office and ask me for advice, I can look back and they tell me their situation. I could probably find something very similar and say, well, I think this is what's going to happen in the case. You have something to work with. You can give advice on it. It's called precedent, and this old law was called common law, which developed and made its way to early colonial America, and we do recognize it today it is not the case in criminal law. While common law did have common law crimes such as murder and rape and theft and arson, the process, what followed after the Constitution, was statutes. Congress passed the statutes that are now our criminal law. New York State has a body of law. So every state has its statutory body of criminal law today. But we still use, the courts have to interpret that body of law. So whatever the courts determine relative to the body of law is what the precedent is, will be followed. Let's work back through this. So we talked about precedent. The English Parliament also passed laws in addition to their common law. This form of legislation, when it was required or needed in certain circumstances that wasn't covered under the common law, and we'll call it statutory law for purposes of this conversation, but they would pass their own form of laws, and it was referred to as mala prohibitum. And what that means is that the act that is not necessarily wrong, but it's prohibited by common law. Now, to distinguish that from mala in se, those are our crimes of murder, burglary, rape, arson, and such covered under our common law. And that means mala in se means inherently evil and depraved. I'm going to say those two again. I don't think they're adequately defined in the book, but they're extremely important. So just to recap the section under common law, precedent, that is the law that judges look to or refer back to prior cases to make determinations in the cases that come before them. Mala in se refers to crimes that are inherently evil and depraved. They're defined by common law: murder, burglary, rape, arson. And mala prohibitum are other forms of statutory legislation from the English Parliament. We don't use this terminology now, but for the history, need to know this. Mala prohibitum is defined as act that is not necessarily wrong, but it's prohibited by criminal law. And a prime example of that are crimes that are victimless crimes, like in a rape and a murder and an arson. There's a face, there's a victim. Something like failed to pay taxes. When you fail to pay taxes, it's a crime. So the common law was used and adopted by the American colonies, as I said, and while it is still used today for criminal law, the laws are defined strictly by statute, and it's called statutory law. Congress has set forth the federal law, and each state has its own body of criminal law. In New York State, it's called the New York State Penal Law Code. The contemporary criminal law divides our crimes into categories. You might be familiar with these. We have felonies and we have misdemeanors. Those are crimes. If somebody's convicted of a felony or a misdemeanor, it results in having a criminal record. I am also going to add here, it's not in the book, there's a level below misdemeanors that's called the violations in some states, or infractions. In New York, we call them violations. And those are things that are only punishable by a fine. Traffic ticket, a noise violation, you're disturbing the peace, those sorts of things. Felonies, most serious. Those result in prison or possibly the death penalty, depending on what state you are in. And those are the most serious. Murder, rape, robbery, arson, all fall into that. There are some felonies that are not so serious, nonviolent felonies, theft. Usually there's certain levels of theft that fall into that category where a court may impose prison or some other lighter type of supervision. We have misdemeanors, which are the low stuff, and criminal mischief falls here, like damaging somebody else's property. In some states, disturbing the peace would be considered a misdemeanor. It's not in New York. It's a violation. And a theft, a petty theft, a simple assault, punching somebody out might be a misdemeanor. So that's how our contemporary criminal law breaks down. In passing laws and having such sanctions, the government expects to do what? They want to achieve a number of goals. They just don't kind of do it willy-nilly. They have some reasons behind it. Some of them, seven of them, enforcing social control. They're all listed in the book. Enforcing social control. Discourages revenge. You don't want the victim taking their own action. Public opinion. This is what the public wants. Public wants there to be laws against driving while intoxicated. Teaches moral values. People learn to distinguish what's appropriate and what's prohibited so we can live amongst each other in society. Deters criminal behavior. The punishment has to fit the crime. It applies just desert, I think is how they describe it, quote unquote, in the book, meaning that those people who commit crimes, they deserve their punishment. It's deserved punishment. Creates equity. Criminal law redistributes illegal gains and gives back to society. So if this allows payback, where defendants pay back, whether it's through some form of, depending on the crime, it could be a community service, it could be monetary, but it creates equity. I think there was one more, social order. Maintains social order. I kind of tied it in with the one above, enforces social control, but it maintains the social order. It keeps us in check so we can live amongst each other. All right, so that is the criminal law system in a nutshell.